All right then, Harrington here, folks. All right, let's do this. So today I want to talk to primarily landlords, but not only. I mean, if you own a property, then this relates to you. I'm talking about occupants that you want to get out of your place. Now, before you give me the Jeff, I saw episode 29. You were grousing for like 10 minutes. That's true. I had lost a hearing and I was not happy about it. And I did let you know so that you wouldn't make the same mistake that I made, or at least let you know the development that this judge has created. But I'm not going to repeat that material. I got new stuff for you here today. So what I'm going to get into here today are the 3 ways to get somebody out of your property. Now, you typically think eviction, right? Everybody thinks eviction. And when you can do an eviction, that's a beautiful thing. We'll get into that. But not always. It doesn't apply to all situations. And if you run into court with the wrong legal theory, if you're asking for an eviction when it really should be an ejectment or it should be an unlawful detainer, then you're going to get your case dismissed, and that's more time that you're going to have this jackass in your property, and you know how you're going to feel about that. So let's talk. Boom. Our Practice Makes Perfect is the podcast for business owners and real estate investors, siempre con un cariño especial para los clientes extranjeros. Part 1. All right, let's start with evictions because that's the easy one. If you can do an eviction, then you'll want to do so because you get some nice statutory protections. Maybe judges here in Florida, I won't speak to California, but in Florida at least, I think the judges tend to be a little bit landlord friendly. And so if you can do that, if that's appropriate for your situation, that's what you want to do. Like you get your attorney's fees. There's some onerous requirements on the tenant about putting the rent in the court registry. It's a nice thing. So when can you evict? Well, you can evict when there's a landlord-tenant relationship and you have a lease agreement. So if you have a written lease agreement, that's a no-brainer. Eviction is what you want to do. What about situations where you had a written lease agreement and then it expired, but the tenant stayed on? Do you then have to do something different, or can you do an eviction? No, you can still do an eviction in that situation as well. All right, what about a situation where it's all oral? You guys didn't write anything down, but it's understood. You guys had an understanding that you're the landlord and they're going to be the tenant and they're paying their usually monthly rent, and there's some history there that you can demonstrate. Well, you're on less firm footing in that situation, but if I were you, I would still bring an eviction count. It should work. And in any event, remember, you can bring multiple counts. You can try different theories. Make sure that eviction is one of them. But just to briefly touch, I don't want to take the thunder out on the next parts, but let's say, you have an ex who you broke up with and he or she doesn't want to get out. Can you evict that person? No. What about, a squatter? Can you evict that person? No, because there's no landlord-tenant relationship, and there never was. So eviction is not going to work in those situations. Okay, so then that brings us right into part 2. What do we do when there is no lease, oral or written, but you got somebody in your property? So let's take some examples. How about, for example, where somebody sold you a property, and after the closing, they just stayed. You got to get them out. They're not your tenant. So what are you going to do? Well, this is ejectment. That's an ejectment situation. Same thing could be for a squatter. Somebody got in, and they just stay there. You're not allowed, remember, in Florida, you're not allowed to go in there with a baseball bat and get them out, frontier style. Here's another situation you might not have thought of. What if somebody builds a shed, like your neighbor, not somebody, your neighbor builds a shed and they encroach on your property? That too would be an ejectment action. What are the features about an ejectment action? I mean, it's not my favorite, and I'll tell you why. One of the reasons is you have to bring it in circuit court. You can't do it in county court. And circuit court cases tend to be longer and maybe just a tiny bit more expensive, but just procedurally, you don't have those nice mechanisms that a county court is set up with, like in eviction actions. I mean, everything just happens so automatically. The judges, at least here in Palm Beach County, the judges are fantastic. You go into court and then things just happen, like right away. Orders start issuing. You don't even have to make motions. Orders come out automatically in establishing deadlines. So things move quite expeditiously, unless the tenant does something crazy to slow things down. But you don't get any of that in ejectment. You're in circuit court. These judges, they're not familiar and they don't care about all those mechanisms that I'm talking about. So it's going to be slower. It's going to be a little bit more expensive. And here's another thing. You don't necessarily get your attorney's fees, because under the landlord-tenant statutes, you have a statute that awards fees to the prevailing party. And usually if there's a lease agreement, you're also going to have a clause there for attorney's fees to the prevailing party. There is no such mechanism in an ejectment. There is no lease, and there's no statute that gives you the right to recover your fees. So those are a couple of disadvantages to an ejectment action. Nonetheless, though, you need to know about it because there are going to be circumstances where you need to do an ejectment, and at least you have a way of getting these people out. So that's part 2. Part 3, I have saved the best for last. I mean, eviction is beautiful if you can do it, but if you don't have a lease, then you're going to want to look carefully at unlawful detainer. That's going to be your best bet. You would take that over an ejectment any day. Just touch on a couple of examples. Again, the X's. If you had somebody living in the property and they had permission to be there, and that's the basic theory of an unlawful detainer action. That usually the person had some right to be there at some point, and then that right ended and they didn't leave. So, here's some obvious examples, X's, and then maybe an employer-employee relationship. Maybe the employer provided some housing for the worker, and then so the worker was there legally, lawfully, initially, and then the employment ended, and the employee just didn't go. I've also seen it come up with caretakers. Some caretakers live in. I've seen it happen where the person being taken care of passes away, and then the caretaker just sticks around. That also comes up. Squatters don't actually fit the bill because they never had a legal right to be in the property. Nonetheless, I would try it if I were you. I would try unlawful detainer. So why do I like unlawful detainer over ejectment? Well, because you can bring it in county court. So you back down in the lower court where things happen more quickly. Now, you don't have all the beautiful mechanisms that you get in an eviction. You're not going to get all these automatic orders. Nonetheless, things are going to move more quickly and be more cost effective, more than likely. So just to end this segment, those are your 3 options. You can evict, you can eject, or you can bring an unlawful detainer action. And you need to know which one is appropriate to what circumstances so that you don't get your case dismissed on you. In conclusion, let's just switch gears a little bit. We've been talking about possession, but usually, there's always a damages component as well. You then have to decide whether it's worthwhile to bring account for damages. What do I mean by that? Well, 2 things. First of all, as for evictions, you're entitled to what's called summary proceedings as to the possession count. So why would you maybe not bring account for damages? Well, let's go back into eviction because you don't necessarily get these in the other 2. But there's something called summary proceedings, which you love whenever you can get it because it expedites things quite a lot. So, but you only get that for possession, your possession count. You don't get that for damages. You can bifurcate. You're allowed to separate your possession count from your damages count and have the judge expedite the proceedings as to possession, and then the damages will just take the time it takes. So that's an option. But as all of you who are landlords know, very often you're just not going to bother with the damages. You don't think you're going to be able to collect on this person anyway. If they're missing their rental payments, then, what are your chances of actually chasing them down, getting money out of them? You may just forego the damages count altogether. One obvious exception to that, however, may be in commercial landlord-tenant cases, or any situation where you have where the defendant in the case is a company or somebody who has a steady job, their wages can be garnished, or they just have money and you think you're going to be able to get it out of them. So in those events, you're going to want to go after the damages as well. Last comment, and then I'm going to leave you guys alone on this. These things do get emotional. By golly, they do get emotional. And I understand it. As you'll recall from my episode 29, I'm from time to time a landlord myself, so I completely understand how tough this is when you have somebody who, we're back to the landlord-tenant situation, but somebody's defaulted on the rent, so you don't have that money. You're coming out of pocket now for the carrying costs. God help you if you have a mortgage, and now you're getting killed. Plus, then you have to lose time in getting this person out. They're going to make you go through the judicial process. The time that it takes to find a new tenant to get in there, fixing up the place, and then attorney's fees on top of that. So I get it. I would just caution you not to get so emotional that you make a bad decision when it comes to pursuing damages or not. So that's what I got for you guys today. If you have an occupant who needs to piss off, remember you got those 3 ways of getting it done. And recuerda como siempre que hablamos español. And you know what to do, the honorable thing down there with the likes and whatnot. I will see you guys next time.